Welcome to Books for Beneficiaries. My name is Pete Williams, the host of the program on which we talk about the needs and rights of beneficiaries when it comes to estate planning. I wanted to follow up very quickly with a short episode on something I brought up last time, and that is when assets are paid out of a living trust. Often there is just simply an immediate payout. So a settlor passes away, and in their living trust, they simply say, pay my taxes, clean up my debts, and then just pay out in 3 equal shares to my 3 children. But sometimes that is not the case. Sometimes assets are actually held in trust for a period of time. And it may be for any number of reasons, a certain age, a number of years. It could be under certain circumstances. And generally, the settlor, when they're deferring payment, often has a concern that leaving an estate outright to an heir all at once is not good for the beneficiary. They want to parcel it out or make sure that the beneficiary is mature enough to handle the distribution. So what I'm going to do is use the example of a delayed distribution. In this sample trust, the settlor has said, look, pay out 1/4 to the beneficiary at age 30, and then pay out 1/3 of the remaining at age 40, 1/2 of the remaining at age 50, and the remainder of age 60. And just to explain my math very quickly, the idea here is to divide the estate into 4 approximately equal shares. And you do that when you have the whole pie, cut it into 4s. Once 1/4 is distributed, then you have 3/4 left. So what the settlor should say in the trust document is leave 1/3 of the remaining, because we have 3/4. Okay, enough math. You get the idea. That's why it's 1/4, 1/3, 1/2, and the remaining. So again, back to our example. The question becomes, what happens if there is an emergency at, say, age 45? So in our example, the beneficiary has received their age 30 distribution, they receive their age 40 distribution, and now they're age 45, and they're waiting on their age 50 distribution. And suppose an emergency comes up. It could be a medical emergency where they need a large amount of money. And it could be a simple car accident where they need to buy a new car. Something happens in between those periods wherein the beneficiary needs money. Do they have to wait to age 50 in our example? Or is there an out prior to that? Is there a way to get distributions out? Well, the answer is yes, there is. And it's something called the HEMS language. HEMS stands for Health, Education, Maintenance, and Support. And that specifies that if there is a health crisis, if there is a need for education money or maintenance on their lifestyle or support for some reason, then payments can be made. And here's some sample language. The trustee shall pay to or apply for the benefit of the beneficiary as much of the trust income and principal as the trustee considers necessary for the beneficiary's proper health, education, maintenance, and support. And by the way, this language there's not a big red light that goes off inside the trust document. You may have to search for this language to see that it's there. It's always nice when the document further defines what these terms mean. What is health? What do we mean by health? Do we mean minor trips to checkups, or do we mean major hospital visits? Education, does it mean K through 12 plus a university degree, or does it include a trade school? So suppose a beneficiary needs money to go to learn how to become a tradesman. Is that okay? HEMS language is also sometimes followed by language that allows for the purchase of a home. Remember, the original intent often with these stretched out payments is to protect the beneficiary from him or herself and to protect from outside undue influence. But the purchase of a home in the beneficiary's name would be a cutout to that, so that there's not a concern. So the trustee may include language that allows for the purchase of a home. Here's some sample language for home purchases. So in addition, for complete distribution of the beneficiary's interest and notwithstanding the other provisions of this paragraph, trustee may make distribution for the purchase of a residence by and for the beneficiary out of such beneficiary share. So this makes sense. We want to protect the beneficiary, and yet by buying a home, settlor may feel a little more comfortable by allowing the trustee to do that. So again, this is some language that allows for payment out of the trust prior to the scheduled payments. In our example, we use an age 45. If a 45-year-old beneficiary has the opportunity to buy a home, the trustee does not have to wait to that age 50 distribution and has the opportunity to pay out assets to the beneficiary for that purchase. Now, you sometimes get disagreements between trustees and beneficiaries. What is health? What is education? How about a new sports car? Suppose the beneficiary is an influencer and the beneficiary argues, hey, I need a brand new sports car because that provides me with a certain look that I need in order to monetize my influencing career. How about a trip to Europe? Beneficiary might well say, I'm in therapy. I've been under a lot of stress. I've been told by a therapist to take off and go get some rest and relaxation somewhere. And I've read about wonderful places in Europe where I can do that. Steve might say, there's plenty of opportunity in the United States. You don't need to go to Europe. And by the way, if you are a beneficiary in this situation, be ready to argue your case, because certainly the trustee is going to ask, hey, we just paid you at age 40 a lump sum. What happened to that money? Where did it go? Why do you not still have some of that left over to pay for some of these things you are now looking for? So you can get into some debates about whether something should be distributed or not. In order to resolve some of these issues between a trustee and beneficiary, sometimes there's language in the trustee that names a special trustee. The special trustee can act as a referee in determining what is a payout to the beneficiary. Sometimes there's a protector. Generally, a protector is someone who can hire and fire a trustee. Having that right can be used to resolve differences between beneficiaries and trustees. There is also mediation arbitrations. This is an opportunity to go before somebody and have a talk and plead a case. So each party pleads their case before a mediator, and the mediator makes a decision. It sometimes is non-binding, but it tells you where things might go if you went to court. And finally, there is court. You can take your trustee to court and say, hey, what I'm asking for is perfectly legitimate, and yet my trustee won't pay for it. So I'm basically suing. Now, I want to caution all beneficiaries that are thinking about court action against their trustees. Most trusts have a no contest clause. The no contest clause says if anybody thwarts the settlor's desires in their trust with their estate, they are disinherited. So you have to be very careful that you are not triggering the no contest clause when you take action against your trustee for payment. And my opinion is you probably want to hire an attorney for these cases where you're taking action against a trustee so that you don't trigger that clause. Okay, thank you very much. I just wanted to bring out this very quickly. Again, today's lesson was we've got these extended structured payments out of the living trust after the settlor dies. Do we have to follow that structure, or is there a shortcut way of getting some assets out before the structured payment is due? And you can take a look at language in the settlor's trust to see if perhaps you can get money out early. And just remember that the information provided here is for general education purposes only and should not be construed as legal, investment, or tax advice. For specific guidance in these areas, please consult your own qualified professional who knows your specific situation. Thank you very much, and we'll look forward to seeing you in the next chapter. Thanks.